Hello, everyone. I'm Brogan Sullivan, partner in Husch Blackwell's Renewable Energy Group. Welcome to the next installment of our webinar series, Building the Renewable Energy Project. This installment is called Project Structuring 101. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your screen, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We'll try to answer all your questions during the webcast, but if a fuller answer is needed or we run out of time, we will answer your question via email later. A PDF of the presentation is available in the resources folder. This program has been approved for CLE hours, so to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for you to watch and share as you like. Toward the end of the program, please be sure to complete our short survey. We will use your feedback to plan future programs that are relevant to you. That is all for the housekeeping items, and let's get started with our program. We're going to start today with a legislative update from Eric Lawson with HB Strategies. We intend for this to be a new feature at the beginning of all of our webcasts. Husch Blackwell Strategies is a federal and state government relations firm affiliated with the law firm Husch Blackwell. HBS offers clients public policy advocacy, political insight, and communication services through 6 offices, including its main office in Washington, D.C. Eric is a principal in HBS. He's a seasoned congressional and government affairs professional with more than 20 years of public sector experience. His experience includes serving as chief of staff for over 8 years to Congressman Daniel Lipinski of Illinois, as well as serving as legislative director in 3 congressional offices. During his time with Representative Lipinski, Eric acted as lead policy and political advisor, providing oversight for the congressman's active legislative and policy program, as well as overseeing his service as chairman of the House Railroad, Pipelines, and Hazardous Materials Subcommittee and chairman of the Subcommittee on Research and Technology. Eric now manages client interests in federal policy involving transportation and transit, energy, advanced manufacturing, communications, aviation, and other issues. Eric resides in Washington, D.C. and works from the HB Strategies office there. So Eric, you can take it away.
Great. Thank you, Brogan. It's nice to join you all today, and I look forward to taking part in these webinars as this year moves ahead. I would like today to give you a quick update on some legislation called the GREEN Act that was introduced earlier this month. This legislation is a long-term effort to address tax policies that induce or incentivize renewable energy, clean energy, green investment, both in the power sector as well as elsewhere in areas such as vehicles. I will focus today on renewable energy sector, but if there are questions or an interest in alternative fuel vehicles or electric vehicles or some of the other areas, I'd be happy to brief folks on that at a later date. Next slide, please. The GREEN Act, The GREEN Act is the Growing Renewable Energy and Efficiency Now Act. Congress loves their acronyms. It was introduced by Congressman Mike Thompson on February 5th. Congressman Thompson represents Northern California in the Napa and Sonoma Valley areas north of San Francisco, and is among the more senior members of the House Ways and Means Committee and the chairman of the Select Revenue Measures Committee, which oversees tax policy. The bill is co-sponsored by every single Democrat on the Ways and Means Committee, as well as a number of other Democrats, but only Democrats so far. Based on a version of this legislation that was introduced last year, the overall 10-year estimate of the budget effect of this bill is about $124 billion over 10 years. This legislation is updated from a version that was introduced last summer to reflect the extensions of the production and investment tax credits and the inclusion of offshore wind in the investment tax credit that were included at the end-of-year legislation passed by Congress in December. The intent of this is to provide long-term certainty in tax policy for developers of renewable energy projects and manufacturers of electric vehicles, among other areas, which is certainly preferable to the short-term, often retroactive nature of tax extender policy. The main sections of this legislation include extensions and certain phase-outs of the production tax credit, the investment tax credit, and the tax credits afforded for carbon capture under 45Q, as well as the extension and phase-outs of tax policy for certain renewable fuels, as entered tax credits for individuals in both home settings as well as corporate settings, tax credits related to electric and zero-emission vehicles, certain green workforce investments, and a provision related to environmental justice. Specifically with regards to the renewable energy tax credit provisions, the bill would extend the production tax credit through 2026, revise the tax credit application for certain facilities that had been discontinued, including landfill gas, trash, municipal solid waste, qualified hydropower, and marine and hydrokinetic renewable facilities. It extends the investment tax credit and phase downs credit after 2025-26. The investment tax credit is expanded to now include energy storage technology that is specific to power storage, not for transport or power generation, as well as biogas property and linear generators. The 45Q tax credit is extended to include any construction of projects before 2026. There is a new provision included that allows a certain form of a refundable credit under 45Q, the investment tax credit and the production tax credit, with the intent of allowing entities that may have no tax liabilities or to have to extend those credits out over a long period of time to claim them at an 85% discount in a nearer term. And this section also expands the 7704 publicly traded partnerships provisions to include, for the first time, green and renewable energy investments for projects that are related to energy production under PTC, property eligible under the investment tax credit, and projects and investments related to renewable fuels and carbon capture and sequestration or gasification. According to Congressman Thompson's staff, it's possible that as this bill proceeds, that additional provisions will be added to expand the electric vehicle tax credit and to add some new provisions related to labor measures. Moving ahead, we're not entirely certain when this is going to come up before the committee because the intent of congressional Democrats and President Biden right now is to focus on the COVID crisis. We know that there is a reconciliation bill moving forward to carry forward that $1.9 trillion COVID package at the current time, and it's possible that later this year a second reconciliation process will be pursued to try and carry forward infrastructure tax or climate change legislation that can fit within the constructs of that. But that aside, it is the intent of Chairman Neal to move this legislation through the committee, perhaps in the late spring, and it seems likely that they will package this tax policy together with a broader climate change and infrastructure bill as they did last year. Likelihood of this moving ahead is much greater with a president that is very interested in trying to secure new and expanded policies with regard to climate change investments, and with the democratically controlled Senate. However, with the 50-50 vote margin in the Senate, it certainly creates challenges of doing things in a bipartisan fashion or to do them in a partisan fashion, which is why we may see the partisan approach under reconciliation recur again later this year. That is it for my presentation, and I welcome any questions that you might have.
Thanks, Eric, and we'll keep track of questions, and to the extent you're not able to stick around for the entire presentation, we'll make sure to get those to you and you can answer them via email.
Thank you.
All right, thanks. It's very informative, and I would be much preferred to have some comprehensive legislation rather than the ad hoc legislative solutions that we've had in the recent past. So now to move on to our Project Structuring 101 webcast, joining me today are Drew Bergman and Mary Sprouse. Their more complete bios are available on our website, but Drew and Mary are both transactional law specialists with a focus on the energy industry based here in our Kansas City office. I have worked extensively with both Drew and Mary. They are excellent lawyers and excellent individuals, and we're lucky to have them on our team. Mary is a senior associate in our group, and Drew just made partner this year, and he is highly deserving of that status. In terms of an agenda, Mary is going to present a couple of overview slides talking about project timeline and just basic entity structure points. And she's also going to cover early stage project development issues. Drew will then take over to discuss mid-stage development issues and financing stage issues. And then finally, I'll conclude with a refresher on federal income tax incentives and some of the structuring issues that come along with that. And hopefully, if we have time, to touch briefly on the partnership flip transaction structure. So with that, I'll turn it over to Mary.
Thanks, Brogan. So we've split our presentation into a few different phases of a typical project. We have the early stage project development, the mid-stage project development, and the financing stage. This slide illustrates where those phases occur with respect to major project milestones. The early to mid stages are really more fluid, but we've split them in our presentation so that we can talk about the scenario of an early stage developer selling a project to a larger scale developer or the entity that will be the long-term owner or sponsor of the project. In the early stages of project development, developers will be securing land rights, working on initial permits, procuring feasibility studies, applying for interconnection, and working on an off-taker commitment. With the prevalence of hedging and corporate PPAs, frankly, the off-taker commitment can really be pushed to the mid-stage development phase 2. If the initial developer is doing a pre-notice to proceed sale, the developer can also be preparing for that sale to the next phase developer. In the mid-stage of project development, the developer will be negotiating key project agreements such as the equipment supply agreements, the engineering procurement and construction agreement, the interconnection agreement, etc. The developer should also be procuring key project reports, including the environmental report, the wind or solar resource report, the independent engineering report, the transmission report, and the appraisal. In this phase, you'll also be negotiating the construction loan and the tax equity commitment. The construction loan and the tax equity commitment don't necessarily need to be negotiated at the same time, but as Drew will speak to later, there can be some cost savings with getting them done on that same timeline. The next stage is what we've called the financing stage, but we also could have called this the construction phase. Once you hit notice to proceed under the EPC contract, you'll start building the project. In this financing stage, the developer will need to manage the construction loan. So typically any material change orders, defaults under key project agreements, etc., will need to be reviewed by the construction lender and likely the independent engineer as well, depending on what your loan doc says. If you have tax equity signed up at NTP, the tax equity investor will also likely want to review and potentially approve change orders to the key project documents and other modifications to those project documents. So while you can get tax equity signed up as early as NTP, I've also worked on projects where the tax equity investment is negotiated during this financing stage. Either way, the tax equity investor does not fund the project until the project starts producing tax credits. So at commercial operation date, the tax equity investor will come in, make their contribution to the project, and those funds will get used to pay off the construction lender. This next slide includes a typical project structure. The heart of this structure is the project company. All key project agreements, permits, and land agreements should be in the name of the project company. The project company is then wholly owned by a holding company, which we've called holdco on the slide. And that entity is typically wholly owned by a sponsor entity. In terms of the construction lenders down on the right, the project company will also be the borrower under the construction loan. The construction lender will enter into collateral assignments with the third parties to key project agreements, which we've noted at the bottom of the screen. Additionally, the construction lender will want to pledge from holdco of its interest in project company. And we've also had some construction lenders want to pledge of holdco because it's the tax equity partnership. And as an aside, I've worked with several clients on several projects where the sponsor entity is a joint venture. So be aware that the sponsor may have to pledge its rights in holdco, which means if you do have a JV, you'll need to get the consent from the JV partner to make that pledge. You could also insert another entity between that holdco and sponsor entity to ensure that pledge is seamless. Up in the left-hand corner, we have the tax equity investor. The tax equity investor will enter into an equity capital contribution agreement with sponsor, which reflects the terms of its investment in the project. Drew will talk more about that shortly. The tax equity investor and sponsor will enter into a limited liability company operating agreement of holdco that governs the management of that entity. Note that the construction lender will also want to consent to collateral assignment of the ECCA, which can be heavily negotiated, and Drew will talk more about that as well. On the next slide, I'm talking about negotiating project agreements. So like I showed on the last slide, all project agreements should be in the name of the project company. Typically, I'd say most developers get this right. I have seen some services agreements, however, be in the name of the parent entity. So while the services under such agreement may have already been performed or even be complete, there could be ongoing indemnification obligations, particularly in the case of a project sale that the sponsor or new developer may want tied to the project. And having gone through that before, there's a lot of times those services providers will then, they don't even really realize that they have those indemnification obligations, and then they'll try to renegotiate when you are trying to get consent. So it's always good to make sure that those services agreements are also in the name of the project company so you don't have to deal with that. Other items that are more often not in the project company's name, but that should be, are the security deposits, say for interconnection, and the project report. So for security deposits, theoretically, the developer should be contributing the cash required for the project to the project company. And then the project company should be making the payment to the party requiring the deposit. For interconnection deposits, a lot of times what will happen is a parent company will send the money directly to the interconnection provider, which, while not ideal, is fine. But you should make sure that the interconnection provider is aware that if the deposit does need to be returned for some reason, it should be returned to the project company. And typically there will be some sort of document on file with the ISO that will document that return. With respect to project reports, not having a report in the project company's name can cause reliance issues during a sale of the project or project financing. I've had some clients whose parent company procured the report, so then the reliance language in the report allows that parent company to rely on the report, but not the project company. So you really want the project company to be the party that's allowed to rely on the report, especially if the project gets sold. Sometimes lenders or tax equity providers will request that the project company be added as a relying party. So frankly, it's just easier to have the reports in the project company's name from the get-go. It'll save you time. So the bottom line is that the developer should really make sure that the project's assets are tied to the project company. So when negotiating key project agreements, you'll want to avoid consent rights for changes of control, collateral assignments, and assignments. So typically, I would suggest thinking about your project structure and the various transfers that will occur, and try to avoid giving third parties the right to limit those transfers. If you have a third party that is requiring some sort of consent right for any of these transfers, try including a carve-out for a qualified transferee with a specific objective criteria so that there's no argument on whether that criteria is satisfied. A lot of times we see a specific credit rating and a number of megawatts of experience as criteria, which are easily, which are objective, sorry, not objectionable. In addition to wanting to collaterally assign the project agreements, the construction lenders will also want step-in rights that allow the lender to step into the project company's obligation if the project company defaults on its loan. So make sure that those step-in rights for lenders are also in your key project documents as well. So on the next slide, I'll be talking about diligence and some cost-saving ideas. For the sale of a project company to another developer, or when you start working on your construction loan or tax equity financing, one of the first steps will be setting up a data room for the buyer's or lender's due diligence. Organizing your data room in a user-friendly manner can save you time and money. I personally like data sites that have the ability to tell you what documents have been added since the last date that you checked. I know Interlinks has this feature and others may as well. If you don't have flexibility in choosing your data room provider, something as easy as numbering folders and subfolders can make the back and forth in diligence much smoother. I know that sounds very basic, but it really does help a lot when people are trying to locate files. Additionally, if you have an issue of concern on the project, we'd recommend getting out in front of it by adding documentation to the data room that helps the reviewer determine whether the issue is of concern to them. Issues of concern will very likely surface during project diligence, and so the earlier they surface, the earlier you can get them resolved. It's never fun to be sorting out some sort of resolution to an issue that you've known about the whole time, days before you're trying to get all the big deal documents signed. So always just try to get ahead of those things and provide information when you can. Lastly, it's helpful to have a team of folks who are dedicated to the diligence process. Have one person at the developer who is managing the diligence and who delegates the questions to the various disciplines within its organization. I would recommend giving this team the heads up that responses are expected within some X number of days, and sometimes questions go back and forth between the parties multiple times before getting resolved. So if the diligence team is taking weeks to respond, this can really slow down your transaction timeline. So next, my colleague Drew is going to talk about project considerations when a developer sells a project to another, usually larger developer or sponsor, as well as all the other various items I claimed he would talk about. Drew?
Great, thanks, Mary. As was mentioned earlier, what I'm going to be covering is the issues that a renewable energy product is going to face during the mid-stage project development through the financing stage. If the developer will not be the long-term owner of a project, the end goal for that developer is going to be to sell the project to a sponsor who's going to own the project through a commercial operation. The sale to the sponsor will occur upon the achievement of certain development milestones and often at notice to proceed or NTP for the project. As Mary mentioned earlier, in some projects there is an early stage developer who will complete some of the initial development requirements for a project, things like obtaining necessary land rights, establishing a spot in the interconnection queue, and at least beginning the permitting process. And then at that point, they're going to sell the project to another developer who's going to complete the development and take it to a leased NTP before selling it to a sponsor. The sale of a project will be structured as a direct or indirect sale of the equity of the project company. This is why some of the stuff that Mary said earlier about keeping all of the project agreements and permits and stuff in the project company is so important. The buyer, whether it's a second developer or a sponsor, is going to need to make sure that the project company is clean when they buy it. And by clean, we mean that there are no historical activities except the development of the project. Some examples of things that could potentially be issues here would be that the project company has had employees at some point, or at some point there were some assets related to another project that was either moved to another project company or was abandoned by the developer. If that's the case, then the seller is going to need to transfer the assets of the project to a new project company entity prior to the sale. The reason this is important is because the financing parties, the construction lender and tax equity investor, are going to expect this and require that the sponsor or whoever is entering into the agreements with them are going to make reps and warranties certifying that there have been no historical activities. So it's important that the buyer is able to get these reps and warranties from the seller as well so that it can protect itself when it's making those reps and warranties onto the financing parties. When structuring an acquisition, the buyer needs to ensure that the obligations related to the acquisition will be solely those of the buyer and not for the project company. As this is another thing that the construction lender and tax equity investor are going to want. The financing parties here are also going to expect that the seller is going to provide an express acknowledgement that the project company is not responsible for any of the acquisition obligations. If this isn't in the purchase agreement, they're going to want it in some type of consent to collateral assignment or estoppel or something like that. If this is not, in order to adequately insulate the project company and financing parties from its acquisition obligations, a buyer should ensure that there's going to be at least one holding company entity in place that's between the buyer and project company in the organizational structure. This is the holdco entity that was in the slide earlier and Mary referred to. This will allow the tax equity investor to make their investment into an entity that is not the project company, but it's also not going to have these acquisition obligations. So if you don't have this in place when you acquire the project, it's going to be something that you're going to have to do as you move forward. When a project's sold by a developer, typically a portion of the purchase price will be what's typically referred to as a developer fee that is deferred until certain project milestones are reached. Often a portion of the developer fee is not due and payable until commercial operation date or COD for the project. Because the seller will no longer have control after selling a project and therefore not be able to ensure that these milestones are actually met, the seller will typically want to have protections in the purchase agreement in case the buyer is unable to achieve these milestones in the timing that the developer would expect. Often the seller is going to be given a repurchase right to buy the project back from the buyer if it fails to achieve the milestone by a specified outside date. And sellers sometimes often want to receive a security interest in the project to secure those obligations as well. It's important if you're a buyer, whether you're a secondary developer or the sponsor, that you make sure that if there is going to be a construction loan, then the construction lenders are going to want to require that any rights like this for a seller are going to expire before the financing agreement is signed and funded. Typically, this is going to occur once the project meets NTP, so we need to make sure that the expiration of these rights coincides with that. Another issue that a sponsor should be aware of when negotiating the terms of the developer fee is that it's going to be very important to the tax equity investor that it does not fund into a project with a purchase price dispute. So if a sponsor is going to be required to pay any portion of the developer fee at or after COD that is going to be subject to an adjustment, then these adjustments need to be objectively determinable as possible with a rapid dispute resolution mechanism. So this will allow the buyer and in the project in general to avoid any lengthy disputes with the initial developer. For projects where the construction of the project is funded with a construction loan, the financing agreement with the construction lender will be signed typically when the project reaches NTP, because this is when the project is going to start incurring construction costs, which will need to be funded by the loan. Otherwise, the sponsor is going to have to fund these project costs themselves, and a lot of sponsors, if not most of them, don't have the capability of doing that, at least for an extended period of time. Under the financing agreement, the project company will be able to make draws to fund construction costs up to a maximum commitment amount. Prior to the execution of the financing agreement, the construction lender will require that a number of items related to the construction operation of the project have been completed. A lot of these items are going to be necessary for NTP as well, so that fits in with the timing there. This would include that the project company has negotiated and typically executed as well both an EPC contract and an offtake agreement. The offtake agreement will be a PPA or a hedge agreement, and we also see on some larger projects that there might be multiple offtake agreements because there's no one offtaker that's going to be willing to buy all the capacity of the project. After the project company has obtained all the land, also the project's going to have had all the land rights and construction permits in order to get the construction loan in the door, plus those are also going to be required for NTP. The construction lender will also want the project company to have entered into an interconnection agreement with the relevant regional transmission organization. We've seen some delays lately in the interconnection process that's created a problem here where there might not be a final interconnection agreement just because the queue is too big at the RTO. So often we've seen situations where there's an interim interconnection agreement in place when the construction loan commitment is made. This makes construction lenders fairly uneasy, so they may want to receive some other separate interconnection-related protection This could be in the form of an indemnity from creditworthy entity for all the interconnection risk and for the benefit of the construction lenders. Construction lenders also going to expect that certain third-party consultants have been engaged and provided reports regarding the project. Mary touched on this earlier. Typically, this is going to include a wind or solar resource consultant, transmission consultant, independent engineer, environmental consultant, appraiser, and in some situations, an insurance consultant as well. Sponsors should ensure that these consultants are engaged early enough in the development process so that when the final reports are needed at NTP, when the financing agreement is going to be executed, that these projects are done and signed off on by the financing party. As was mentioned earlier, if a project is going to have a construction loan, the construction lender is going to start funding at NTP for the project typically. The tax equity investor, on the other hand, is not going to end up providing their funding until at or around commercial operation date or COD for the project. And the funds from the tax equity provider are largely going to repay the outstanding amount due under the construction loan. Because of this timing, the construction lenders are commonly viewing their construction loans less as a traditional asset-based loan that would be based on the value. They don't really look at the eligibility for tax credits, things like that. And instead, they a lot of times are seeing this as more of a bridge loan to a specific tax equity funding. Because of this timing, a construction lender can be expected to be concerned with the terms of tax equity investment, especially those that are going to affect the certainty and amount of the funding as well as the timing. In order to address this, a sponsor should try to negotiate with the construction lender and tax equity investor in tandem and effectively mediate negotiations between a construction lender and tax equity investor. If this isn't done, you can be in a difficult situation where whichever party has signed up the agreement first has a lot of power and ability to potentially change the way that you can negotiate with the second financing party there. Frequently, this back and forth between the tax equity investor and construction lender is going to come to the head in the negotiation of a consent to collateral assignment of the tax equity ECCA, Equity Capital Contribution Agreement, which this consent to collateral assignment is where the sponsor is going to collaterally assign its interest in the ECCA to the construction lender. You can probably expect that this is going to typically be a fairly heavily negotiated document and take some time, and make sure that you plan accordingly and get that moving early. While the tax equity investment does not occur until later in the process at COD, if possible, a sponsor should be trying to negotiate and finalize and execute the tax equity ECCA, which is going to include the commitment for the tax equity funding at the same time or even before the execution of the construction loan financing agreement. If the ECCA is not finalized before the financing agreement, the construction lender is likely going to want an approval right, at least for the material terms. That's going to put the sponsor in a difficult position when trying to negotiate with the tax equity investor, because they're going to have to try to push for the items that the construction lender wanted. Starting early on in the process, there's a number of steps that a sponsor can take to try to make the negotiations between the construction lender and tax equity investor go as smoothly as possible. Quite often, the construction lender and tax equity investor for a project will have worked together in the past, since there's really just a limited number of players in this market. And this is also the case with law firms as well, which is going to largely drive these negotiations. Sponsors should make sure that when selecting the financing partners, that it discusses their experience from working with each other, and they should try to select parties that are going to have a good working relationship. This can be important both in ensuring the uncertainty that the financing of the project actually comes together, but also so that the sponsor can limit the costs of obtaining the financing, because if they've negotiated before, they're probably going to have good starting points and kind of know where the middle ground is going to be. One way to ensure early on in the process that the construction lender and tax equity investor are going to be able to reach an agreement is to include the terms of the tax equity investment that are going to be material to the construction lender in the letter of intent with the tax equity investor. That way, the sponsor is going to be able to ensure that there is an agreement between the financing parties on the key terms before beginning to negotiate the actual long-form construction loan financing agreement and tax equity ECCA. This should help reduce the project's time for negotiations plus expenses. Another way that the sponsor can protect itself early on in the process is that when negotiating a mandate letter that's going to grant exclusivity to a specific tax equity investor, that there is a provision included that's going to allow the sponsor to terminate the tax equity arrangement without penalty if the construction lender and tax equity investor are not able to resolve the material key terms plus the form of the consent to collateral assignment for the ECCA on or before a specified date. This can create an incentive for the tax equity investor to reach an agreement with the construction lender early on in the process, and potentially if they're unable to reach an agreement and get to an impasse, this is a way that the sponsor can reduce the fee it's going to have to pay if it's going to have to break one of these commitments. There are another few tips that we have that we've seen that really help a sponsor to reduce the financing costs, and these are things that you can think about early on in the process. One of these is that both the construction lender and tax equity investor are going to engage local counsel to review issues related to land rights and state and local permitting for the project. A sponsor can try to push for both of the financing parties to use the same local counsel. This is going to avoid duplicating efforts and should reduce costs because you're not paying two firms to do basically the same work. Another item is that a sponsor can also request that financing parties are going to agree to a fee cap or at the very least a fee estimate. And this would be in the LOI process or fairly early on. It's unlikely that even a fee cap is going to be completely binding, as no financing party is going to probably agree to this unless it's highly qualified. But at the very least, having this discussion early on will keep attention focused on the transaction expenses that are going to be involved in financing the project and signal to financing parties that this is going to be important to the sponsor and something that's going to be focused on. As we've mentioned a few times, there are going to be a lot of reports that are required for both a construction loan and a tax equity investment. Things like the wind or solar resource and transmission reports, and a report from the independent engineer. It's going to be important that when you select these third-party consultants, that you make sure that they're going to be acceptable to both the construction lender and the tax equity investor. We've actually ran into situations where a project maybe runs this by one of those two parties, runs it by the construction lender, and they sign off on a specific independent engineer or wind or solar resource consultant. But then the other party comes along and says that they don't approve of that consultant and they want to use someone else. And in that situation, you would basically have to re-engage a completely new consultant and have them redo the work that was already done. It also makes things pretty complicated because you're going to have to go back and work with the original financing party that already approved the original consultant and either have them review the new report, which is going to take time and money, or have them use a different report. And at that point, you're going to have a little bit of a disconnect between your two financing agreements because they're relying on different reports. Another thing that is going to help you reduce costs here is that if you can try to sync the timing of your commitments from your tax equity investor and the construction lender. As I mentioned earlier, this is a good thing in general because it will help you reduce some of the issues that you're going to have between the construction lender and tax equity investor. Because if you don't have one of them sign up first, they're not going to have as much of a right to push changes for the other's documents. Another reason this is good is that you won't have to get multiple versions of reports from your third-party consultants. These typically are fairly expensive to get reissued reports, but if you have a few months between your construction loan financing agreement signed and your tax equity ECCA is signed, then you might have to go ahead and redo those reports because of you might have 3-4 months between them, and typically a financing party is going to have some limit on how old the report's going to be that they accept when they sign up an agreement. Another item that should be on a sponsor's radar early on in the financing process is to prepare a financial model. This is going to be a key item for the project, especially for the tax equity provider, as it's going to provide the basis for their investment in the project. It's going to be a condition to executing the tax equity CCA that there is an original version of the financial model that's approved, and then that's going to be redone and used to adjust the tax equity financing at the funding of the ECCA. Many of the items included in the financial model are going to involve third parties, so it's really important to get to this early. This would include things like you're going to need production estimates for the wind or solar from your consultant. You're going to need costs from your transmission consultant. There's also going to be a lot of things that are going to come from the project contracts and your contractors there. Things like you're going to need to find your construction costs under the ECC or under the EPC contract. You're going to need to know about the location and costs for the interconnection. That's going to come from your interconnection agreement or whatever else you have with the RTO. You're also going to need to get the pricing and key terms for the model, and that's going to come from your offtake agreements. And then once you have these initial items, you're also going to have some of your third-party consultants, like your independent engineer and appraiser, review and approve these items. So this is really a multiple-step process, so it's really important to get this moving early on, because we've seen a lot of scenarios where this is the thing that kind of delays off closing or signing up of an agreement because the model is just not quite ready in place. And with that, I'm going to go ahead and pass it off to Brogan so that he can go in and talk about some of the federal income tax incentive issues.
Great, thank you, Drew. So with respect to federal income tax incentives, this is necessarily going to be high level and something of a refresher. We're going to have a webinar in May that's going to provide more detailed information about tax incentives and other tax issues facing renewable development projects, and we'd invite you to participate in that webinar as well. But, you know, I'm not a tax lawyer, I'm an M&A lawyer, but the tax aspects of these transactions are so fundamentally important that a working knowledge of the key tax issues is a must if you're going to be working on these deals. So with that, federal income tax law provides certain incentives for renewable energy, and the most important of these are the investment tax credit, which is used principally for solar projects, the production tax credit, which is used most often for onshore wind projects, and then the 5-year depreciation deductions, which are important for both wind and solar projects. It's important to keep in mind that these incentives are non-refundable tax benefits, and that means that they can only be realized by a taxpayer that would otherwise owe federal income tax. Many investors in wind or solar projects do not have taxable income that allows them to fully benefit from these tax incentives. And so lawyers and others have created various structures to monetize those benefits for the benefit of the developer. Investment tax credits, the tax code provides generally for a 30% investment tax credit on the amount invested in a qualifying project. The ITC vests over 5 years, 20% each year, such that if the taxpayer disposes of the property within 5 years after it is placed in service, the taxpayer must repay all or a portion of the credit. Also, if a partner's interest in a partnership drops by more than a third, the partner has to repay the IT based upon the proportionate decrease. As one would expect by its name, the production tax credit is completely different. It's based on the amount of electricity that is actually produced at a qualifying facility. The credit is, in 2021, 2.5 cents per kilowatt hours of electricity produced. That's inflation adjusted, so it goes up a little bit each year. And it has to be produced by a taxpayer from a qualified energy source and sold by the taxpayer to an unrelated person during the taxable year. The credit is available during a 10-year period, beginning on the date that the facility is originally placed in service. An interesting point here for wind facilities in particular is that each wind turbine is considered a separate facility for purposes of the PTC. So it's very important to keep track, obviously, of the date on which each wind turbine was placed in service so that you can track the PTC separately for each turbine. Both the ITC and the PTC are legislatively going to phase out over time. As Eric mentioned at the very beginning, hopefully for those of us who make our livelihood doing deals in this space, those credits will be extended further. But at the moment, the ITC gets phased out if construction begins after 2019. It moves down to 26% if construction begins from 2020 to 2022, on down to 22% if construction begins in 2023, and then 10% for property that begins construction in 2024 or after. To get the credit in excess of 10%, the equipment must be placed in service prior to January 1st, 2025. And as you'll see here in red, some of these dates and percentages were pushed out under a law signed by President Trump in late 2020 called the Taxpayer Certainty and Disaster Tax Relief Act. There's also a PTC phase-out for wind facilities. If construction begins in 2016 or earlier, you get 100% credit. If it begins in 2017, 80%. 2018, 60%. 2019, 40%. And then back up to 60% if construction begins in 2020 or 2021. It's obvious. It's odd for the credit to drop down to 40% and then back up to 60%. Such that if you were inclined to start a project in 2019, you might want to wait until 2020 to start construction so you get the bigger credit. But as a practical matter, this didn't really mean very much because developers are so busy trying to get their 2016 and 2017 projects online. Beginning of construction is just a huge concept in wind and solar development because it is determinative, as we just discussed, of the amount of the credit the taxpayer is eligible to receive. And the IRS has provided two alternative tests for establishing when beginning of construction occurs. The first is a more subjective test, and it's physical work of a significant nature. There's no minimum expenditure here. You just have to demonstrate that the work that has occurred is significant. And the work has to be on a portion of the facility that will assist in the generation of electricity. The other test is the 5% safe harbor. And this is satisfied if the taxpayer spends an amount equal to at least 5% of the total cost of the qualified energy facility in a given year. And again, the facility is defined to include only property integral to the production of electricity. So, for instance, the cost to acquire land for the project would not count towards the 5% safe harbor. So, under IRS notices, once you start a construction project, a solar or wind project, the construction has to be continuous. This is not a requirement of the statute, but it was created by the IRS under the legitimate and reasonable concern that they didn't want people to start a project and then sit on them indefinitely and complete them, let's say 10 years later, and qualify for the credit. The problem was, or is, that the continuity standard is very uncertain. There's no clear IRS guidance about what it means for construction to be continuous. Does that mean work has to happen every day, every week, every month? Construction for such a complicated project is necessarily going to involve certain periods of time where not much happens. So what taxpayers do is rely on a safe harbor created by the IRS to provide certainty for satisfying the continuity requirement. And the general rule of the safe harbor is that it will be deemed satisfied if a taxpayer places the facility in service by the end of the 4th calendar year after the calendar year in which construction begins. So if you begin construction in 2016, the facility has to be placed in service by the end of 2020 in order to meet the continuity safe harbor. If you miss the deadline, that's a big problem because you risk losing the tax credit completely. That would be a very terrible outcome. So with respect to 2016 projects, we've had clients that have needed to scramble to try to get projects done by the end of 2020. With the COVID pandemic, we had supply disruptions, construction delays, and to a lesser extent, permitting delays, which basically made it impossible for some of these 2016 projects to get done. Thankfully, at the behest of a bipartisan group of senators and a letter to the Treasury Department, the IRS in May issued a notice granting a 1-year extension for projects that commenced construction in 2016 or 2017. So, if you began a project in 2016, you now have until the end of 2021 to get the project done. And that's really saved a lot of developers from a really bad situation. skip this slide in the interest of time. Just a couple other points about the commencement of construction. So the first test, as we've talked about, or one of the tests, the subjective test, is physical work of a significant nature. Some taxpayers and developers really push the envelope here by contracting out work to construct a key component, but then providing that the work will stop after relatively little progress has been made. And the point here is that that's just very risky, because you've got to get tax equity providers on board with the tax equity strategy, and that strategy is not one that gives a lot of comfort to tax equity providers. But perhaps the most important point here is that whether you approve beginning of construction through this test or the safe harbor, the important thing is that the developer just has to maintain good records and information about the beginning of construction. So you need to keep available contracts for the purchase, construction, or development of a project. You'd have pictures with dates showing the progress made, copies of invoices and payment records, and progress reports. With respect to the 5% safe harbor, one point here, this is another fairly obvious point, is that developers are well advised to provide for a cushion here in case estimated costs end up being greater than expected. Because if total costs are underestimated, you can run into real trouble. If it turns out that you didn't achieve the 5% safe harbor, you can lose the tax credit completely, or back to trying to demonstrate continuity of construction, which is a challenge. For certain kinds of projects like wind projects, this can be addressed. That circumstance can be addressed, for instance, by reducing the size of the project. But for other kinds of projects, for instance, a waste-to-energy project, that failure to properly estimate the amount of total cost can be fatal. Another interesting thing about the safe harbor is that safe harbor property can only be transferred to a related person. And so this has resulted, Mary mentioned that some developers and sponsors are structured as joint ventures. And this is because, in some cases, because the owner of the safe harbor turbines wants to contribute them to a project, and they have to maintain a 20% interest in that project going forward to maintain the safe harbored status of the equipment. The other option is to sell the entire project with the safe harbor components included in them, and that can also work. And again, just like with the other test, it's just fundamentally important to keep good records with respect to the expenditures and the contracts and the assignment documents with respect to the safe harbor components. All right. As mentioned earlier, there are complex structures that have been created to monetize federal income tax benefits. Partnership flips and sale leaseback transactions are the ones we see the most. The inverted lease structures are used mainly in rooftop solar markets. And frankly, what we see most often is the partnership flips. So we'll talk briefly about that. Partnership flips derive from the principle that tax benefits can usually only be claimed by the owners of a project. And partnerships are perfect for this because they offer flexibility in how economic returns from a project can be shared. So they're simple in concept. I'm going to read this pretty directly because it's pretty important. A sponsor will bring in a tax equity investor as a partner to co-own a renewable energy project. Then under the partnership agreement, which is called the LLCA, they're almost always set up as limited liability company agreements, the LLCA will allocate tax credits and taxable income and loss. There will be lots of loss in early years because of the high depreciation, 99% to the tax equity investor until that investor reaches a target yield, which is known as the flip point. After the flip point is reached, the tax equity investor's share drops to 5%, and the sponsor has an option to buy the investor's interest at a fair market value price. So one benefit here of a partnership flip versus, for instance, a sale leaseback is that the sponsor gets to buy the tax equity investor's interest at a low price because the residual value of the tax equity investor is low at that point. It's only at 5%. Before the flip, cash can be distributed in a different ratio than the tax credits and income and losses. This is a highly negotiated commercial point between parties. But if the target yield isn't reached by a target flip date, then those cash distributions are changed so that the tax equity investor gets more cash in order to accelerate the point at which the flip is achieved. In these transactions, the tax equity investor takes the risk that the partnership will be respected for tax purposes, and also takes some operating risk, because if the project doesn't generate cash or income, then the flip may not be reached. The next slide just is a very rudimentary diagram of a partnership flip structure. And it basically goes over what we just spoke about on the prior slide. I'll point out just a couple of things here. In the lower left, you'll see that the sponsor affiliate, or the sponsor itself sometimes, is a party to an O&M contract, an agreement to operate and maintain the project, so usually for a fee. And what the LLCA will provide, the partnership agreement will provide, is that while the sponsor has responsible for day-to-day matters, the tax equity investor will have a veto right over certain bigger decisions or fundamental actions by the tax equity partnership. That list of veto rights, as you would expect, gets pared way back after the flip point is achieved. The other point I'll make here in the lower right is that this shows a PPA to a utility. It obviously doesn't have to be a utility. It can be a hedge agreement. It can be to a corporate off-taker. But if it is a utility, this only works if the sponsor is not related to the utility. And this is one reason it's pretty rare to see utilities sponsor projects that are financed by tax equity, because the losses cannot be used, they cannot be claimed for the sale of electricity to a related party. And we're virtually out of time, so we'll have to get into more details in the webinar in May. The pay-go contributions, this is just a common feature in tax equity deals where the tax equity provider mitigates its risk under provisions that say that a portion of its contribution will be contingent on the actual energy production of the facility. So that amount cannot exceed 25% of the tax equity investor's total contribution. In other words, 75% of the total contribution amount has to be fixed, irrespective of the facility's output. The very last point I'll make is just the first bullet point here. It hasn't been mentioned before. I think we've covered everything else. In an ITC transaction, at least 20% of the tax equity investor's contribution has to be made before the facility is placed in service, because the IRS wants to make sure that that party has an actual interest in the partnership and a risk in the partnership before the project is placed in service. This is not ideal for tax equity investors, because the construction loan typically or often remains outstanding until placed in service, and tax equity investors don't like to invest while the construction loan is outstanding. To deal with this, sponsors and tax equity providers arrange for construction milestones and activities to ensure that placed in service is achieved just within days after the tax equity investment is made. Usually the tax equity investment is made upon mechanical completion, and then the final 80% is made after placed in service or substantial completion, just days or a week or two later. So with that, frankly, we are out of time for questions. We will respond to any questions by email. We really appreciate everybody participating. We hope this information was helpful to you and your organization. Don't forget to report your hours for CLE by clicking the CEU icon at the bottom of the screen. And please be sure to complete our survey so that we can use your feedback to help us plan future programs. This concludes our webinar. Thank you very much.